Hiya, I'm here today, common law assenters, with the Barons Petition, sitting on the famous egg stone on the side of the Tor, because I think that the Barons Petition is the egg. So we're going to hatch the egg today and hopefully give birth to like dragon energies that are going to just like rise up out of the ground. So we're hatching a baby dragon. I'm being silly, but I'm just going to read the Barons Petition. In case you haven't actually been able to read it and understand it yourselves, or never heard of it. So the Barons invoked Article 61 of the Magna Carta in 2001, and this is the petition that they sent to the Queen before they invoked it. So it says, thanks for tuning in, and thank you for joining our Facebook pages and my Patreon. A petition to Her Majesty Queen Elizabeth II, presented under Clause 61 of the Magna Carta 1215, 7th of February 2001, to defend British rights and freedoms. Ma'am, as our humble duty, we draw to your Majesty's attention 1. The loss of our national independence and the erosion of our ancient rights, freedoms and customs since the United Kingdom became a member of the European Economic Community, now the European Union, in 1973. 2. The terms of the Treaty of Nice 2000, which, if ratified, which it was, will cause significant new losses of national independence and further imperil the rights and freedoms of the British people by surrendering powers to the European Union. A. To enter into international treaties binding on the United Kingdom without the consent of your government. B. To ban political parties, deny free association and restrict the free expression of political opinion. C. Which can be used to introduce an alien system of criminal justice, abolish the ancient British rights of habeas corpus and trial by jury, and allow onto British soil men-at-arms from other countries with power of enforcement. D. To create a military force which will place British service personnel under the command of the European Union without reference to British interests and contrary to I. The oath of personal loyalty to the Crown sworn by British forces. Aye. The Queen.
Aye, Captain.
The Queen's Commission, and 3. The United Kingdom's obligations to the North Atlantic Treaty Organisation, which removes the United Kingdom's right to veto decisions not in British interests. The creation by the European Union of a Charter of Fundamental Rights, which purports to give the power to abolish such rights at will. 4. The unlawful use of the royal prerogative to suspend or offend against statutes in ways that are prejudicial and detrimental to your sovereignty, contrary to the Coronation Oath Act of 1688, which subverts the rights and liberties of your loyal subjects, contrary to the ruling in Nichols v. Nichols, 1576. 5. Your Majesty's power to withhold the royal assent and the precedent set by Queen Anne under a similar threat to the security of the realm in 1707. Wherefore, it is our humble duty to petition your Majesty to withhold the royal assent from any parliamentary bill which attempts to ratify the Treaty of Nice, unless and until the people of the United Kingdom have given clear and specific approval to uphold and preserve the rights, freedoms and customs of your loyal subjects as set out in the Magna Carta and the Declaration of Rights, which you, our sovereign, swore before the nation to uphold and preserve in your coronation oath of June 1953. We have the honour to be your Majesty's loyal and obedient subjects. Signed. We usually put all of the people that signed. Oh, it's at the back. So I'm going to continue. There's notes. Should we do this in part 2 or carry on? Should I carry on?
Carry on.
The House of Lords Records Office confirmed in writing as recently as last September that Magna Carta, signed by King John in June 1215, this was in 2001, stands to this day. Home Secretary Jack Straw said as much on the 1st of October 2000, when the Human Rights Act came into force. Halsbury's Laws of England says Magna Carta is as binding upon the Crown today as it was at the day it was sealed at Runnymede. The Treaty of Nice, signed by the British government in December 2000, includes Article 24 transforms the EU into an independent state with powers to enter into treaties with other states, which would then be binding on all member states, subject to agreement determined by qualified majority voting. I thought that was quantity, but anyway, qualified majority voting.
We'll look that one up.
Might be a typo. Article 23 allows the EU to appoint its own representatives in other countries, effectively with ambassadorial status. Article 191 assumes for the EU the right to lay down regulations governing political parties at European level and withdraw or prevent the funding of political parties which do not contribute to forming a European awareness. This is a clear restriction of free speech and free political association. It also introduces two particularly abhorrent propositions: taxation without representation and the use of sanctions to suppress public opinion. Articles 29 and 31 establish common policing and judicial cooperation, Eurojust. Article 67 allows matters of justice and home affairs to be agreed by QMV. These articles open the door to the imposition of corpus juris on the UK, and that's what we can see today, by the way. Article 31 specifically calls for cross-border policing and prosecution and the removal of conflicts of jurisdiction and the deployment of armed Europol law enforcement officers on the streets of Britain. These matters were originally dealt with under Article 280, which mysteriously disappeared from the draft of the Treaty of Nice at the very last minute, in part at least, following heavy pressure from British Euro realists. Article 17 establishes a common foreign and defence policy for the EU with its own military force. The House of Commons was told on 11th of December 2000 that the entire chain of command must remain under the political control and strategic direction of the EU. NATO will be kept informed. Her Majesty the Queen is Commander-in-Chief of all her armed forces and Colonel-in-Chief of 46 of her regiments of the British Army. Every other regiment owing its loyalty directly via another member of the royal family as its Colonel-in-Chief to Her Majesty. The loss of the UK veto applies to 39 new areas of EU competence, including indirect taxation, like the buying of masks. No, sorry, I'm getting carried away there. The environment.
Less said about masks, the better.
The environment, immigration, trade, employment, industrial policy and regional funding. The EU also has plans for QMV to be expended to other areas not agreed at Nice and without further treaty negotiations. Okay, the Charter of Fundamental Rights, signed it by Biarritz, autumn 2000. Article 52 purports to give the EU the power to abolish them at will, effectively making them meaningless. The whole proposition that the state has the right to grant and abolish fundamental human rights, i.e. those that we inherit at birth and hold in trust for future generations, is not only absurd, but contrary to Magna Carta 1215, the Declaration of Rights 1688, and the Bill of Rights 1689. Clause 61 of the Magna Carta was last invoked when the Bishop of Salisbury, Gilbert Burnet, acted on behalf of the Barons and Bishops of England to invite William Orange and Mary to come to London in 1688. After King James II had failed to re-establish Roman Catholicism in England and lost the confidence of the people, his act of abdication was to throw the Great Seal into the Thames and flee the country. The ruling, Nichols v. Nichols, 1576, included the words, "Prerogative is created for the benefit of the people and cannot be exercised to their prejudice. The royal prerogative is the power delegated by the sovereign to ministers to sign treaties on behalf of the nation." In 1707, Queen Anne withheld the royal assent from the Scottish Militia Bill when it became apparent that James Francis Stuart, Pretender Prince of Wales and the Queen's half-brother, was planning with Louis XIV of France to invade Scotland from Calais in an attempt to establish a Jacobite sovereign. Were such an invasion to be successful, the Queen feared a Scottish militia might be turned against the monarchy. Thus Parliament's will was denied in the interest of the sovereignty of the nation and the security of the realm. Addressing both Houses of Parliament on 20th July 1988, at a historic meeting of both houses to mark the 300th anniversary of the Declaration of Rights, Her Majesty said that it was still part of statute law on which the whole foundation and edifice of our parliamentary democracy rests. The Declaration of Rights spells out the details. The said Lords and Commons, being the two Houses of Parliament, should continue to sit and make effectual provision for the settlement of the laws and liberties of this kingdom, so that the same for the future might not be in danger again of being subverted. The particulars aforesaid shall be firmly and strictly holden and observed, and all officers and ministers whatsoever shall serve their majesties and their successors according to the same in all time to come. Both Magna Carta and the Declaration of Rights are contracts between the sovereign and the people. Because they are not statute law, they cannot be repealed. Both proclaimed what were taken to be self-evident freedoms of which exist by right. Equally, both were based on a concept of permanence. Okay, so that's the full Barons Petition with the notes that followed. The list of signatories and peers signing the petition were Lord Ashbourne, the Duke of Rutland, Viscount Masserine and Ferrard as Lord Oriel, Lord Hamilton of Dalzell signed and presented the petition at Buckingham Palace. The petition was also signed by Lord Sudeley, Viscount Cowdray, Viscount Norwich, Lord Napier and Ettrick, Earl of Romney, Earl Kitchener, Lord Napier of Magdala, Lord Elsa, Lord Sandys, Earl Cathcart, Lord Oaksey, Lord Milne, Lord Newell, Lord Barber of Tewkesbury, Lord Dormer, Viscount Exmouth, Lord Wise, Earl of Devon, Earl of Cromer, Earl of Shannon as Lord Carlton, Lord Sandford, Marquis of Aberdeen as Earl Aberdeen, Lord Strathcarron, Lord Craigmile, the Countess of Dysart also signed, but the Dysart title is Scottish and predates the Union of 1707. So I'm going to wrap up there, and I hope that that's hatched this egg so that people can actually start to understand that this is something that happened and it's our law. There's following letters to the Queen's private secretary, Sir Robin Janvrin, which will follow up somewhere else. There's also the evidence that Article 61 was invoked as reported in the Daily Telegraph, which I'll read elsewhere. Hang on a minute, I can hear something.
This is the best bit now.
What's this? Ha! It's an egg.
So it's actually
it's a
hatched.
baby dragon. Yeah, we hatched it.
We hatched it.
It's done.
It's done. Best get your shoes on.